There are a lot of documents. Generally speaking, sometimes you'll get a letter of intent or a term sheet or a memorandum of understanding, all generally speaking the same thing. A non-binding, we're interested in buying your business. Here are our initial terms. And before that even though, typically there is usually the confidentiality non-disclosure agreement. Because if you're out there, especially if you're trying to sell your business to a competitor, you want them to agree at least that, I'm going to tell you everything about my business so you can evaluate whether you want to buy me, but I don't want you to steal my secrets. That's kind of the concept. So that's kind of usually the first step. Sometimes not. It depends on who you're selling to. So, if you're a small startup and you're looking for venture capital financing, generally speaking, they're not going to sign a confidentiality non-disclosure agreement because they see a million of these just like you, and they're just not going to do it. But if it's a going concern, it's a real business, then you have your confidentiality agreement, non-disclosure, usually followed by the term sheet. The term sheet can be negotiated because it has some key provisions in there. Lockups, meaning you can't go shop it somewhere else. Tells some period of exclusivity or something like that. Maybe a breakup fee, which is not that common, but sometimes. And then you usually negotiate the key terms off of that. So generally speaking, this is how much we're going to pay, and this is the stuff that we want to buy. And that's usually followed by what they call the definitive agreements, which is usually either it's an asset purchase agreement, typically, or a stock purchase agreement, sometimes a merger agreement. That's the document that actually acquires. And that will lay out in excruciating detail, what's being paid, how it's calculated, any adjustments that are going to be made to the purchase price, what exactly they're buying, what exactly they're assuming, what they're leaving behind, all that good stuff, along with your representations and warranties that, yes, I own this stuff, these are my creditors, these are my vendors, these are my employees, these are any issues that I know, and I swear it's true. And by the way, in this contract, if anything I say in here is usually materially not true, then I'm going to have to give you some money back. And usually there's a mechanism, an indemnification provision in there. And together with that, there are typically a bunch of what we call ancillary documents that go along with it. A lot of employment agreements, maybe key employees, maybe with the seller if they're going to stay on board for a little while. Usually some non-competes and non-solicits, maybe some intellectual property assignments. Sometimes there's a lease or sublease. Sometimes there's an assignment and assumption agreement of contracts and just intangibles. Usually there's a bill of sale which covers the tangible stuff that you're buying, together with the closing statement and maybe a transition services agreement if you're going to be, say you're selling a division and you're going to assist them in transitioning the division you're selling out. So there are a lot of ancillary documents that can go along with the transaction as well. So it's a lot of paper. We kill a lot of trees.